Are you ready to take control of your wealth and design the life you envision for yourself and your family? Welcome to Wealth of Insight with Austyn Whittenburg from Whittenburg Wealth Partners. Austyn guides you through the entire planning process to help you build a plan that seeks to protect your financial future. He empowers you with creative investment opportunities and planning ideas to help you understand and achieve your long-term goals. It's time to gain confidence in your financial future. Now, on to the show.
Okay, welcome back to the Wealth of Insight podcast. We've got Eric Whiting with us today. He's a partner at Yorkell Guyman, which is a law firm me and my dad have worked with for many, many years, and thought we'd have him on to talk estate planning. Thanks for joining us, Eric.
Hey, thank you. I'm glad to be here.
All right, before we dive too deep into just sort of the basics of an estate plan, thought it makes sense to give you just 60 seconds to talk about how long you've been an attorney, how you sort of got to where you are today.
Yeah, I have been practicing for about 13 years now. I focus on estate planning primarily, do very little else. I'm a tax attorney by background. So after I finished law school, I got an LLM in tax with a certificate in estate planning and employee benefits, and have really focused on estate planning the whole time. So I know an awful lot about I just try and help clients with this piece and make sure they've got the right documents in place. So, a lot of estate planning and business succession planning.
Awesome. Well, that's what we appreciate about you, is that you know a lot, but about this one piece. Was when we're putting together a financial plan for clients, estate planning is a big component of that. And I know enough to be dangerous, but that's why we rely on people like you. So let's get into it here. We've mentioned this word a few times here: estate planning, estate plan, that kind of stuff. What is an estate plan, and why does somebody need to have that put in place?
Yeah, it's a good question. A lot of people think about estate planning as something that only the rich do. And, it's about deciding where your millions of dollars goes. But really, an estate plan is the legal documents that prepare for your passing and determine what is going to happen with your estate after you're gone. So there are questions. If I were to blast off tomorrow, who becomes the guardian of my kids? If I were to blast off tomorrow, where does my money go? How am I going to make sure that if I have, for example, young kids at home, they get the money at the right time, under the right circumstances? And there's a lot of those open questions. Even if you don't have young children, the estate plan is you being in the driver's seat about making sure your stuff goes where you want it to go and in the way that you want it to go to either the next generation or whoever your beneficiaries are at the end of the day. And so a typical estate plan is usually thought of as, last will and testament, a revocable living trust, powers of attorney. It's really all of those things, but each one of those documents has a particular task that it completes for you in making sure that you control and are in the driver's seat for that plan.
So do I really need to pay somebody like you, or can't my family just figure out all this kind of stuff once I'm dead?
Yeah, it's a good question. And, one of the things that an estate plan does is it sort of removes you from the judicial system. A lot of estate planning, so for example, if you don't have an estate plan in place, can you still get mom and dad's house? Sure. You can go through probate. You can walk through that process of transferring title to assets, but it's all under the supervision of the court. So it's a time-consuming, expensive process. People will say, well, do I need financial powers of attorney? Well, you don't have to have them, but you can go through a guardianship and conservatorship process with the court where you're going to end up hiring two attorneys, one to represent you and one to represent the incapacitated individual. You're going to have hearings. It's time-consuming and it's expensive. Who becomes the guardian of your children? Your surviving family members can petition the court for guardianship of your kids, but we don't know who's going to end up doing that petition. We don't know what the court's going to decide. So it leaves a lot of open questions when you don't have the plan in place. A lot of those things can be answered through the court, but again, you're going to drastically increase your cost, the burden, and everything else. Whereas if we have that power of attorney in place, if we have that last will and testament or that trust in place, it's going to answer all those questions ahead of time.
I want to stick on that point here for a second, because I think that's something I didn't really understand, and most people don't understand as it relates to guardians for children. So I in a typical scenario, is that addressed through the will? Maybe we start with the will and we touch on that.
The law allows you under Utah law to nominate an individual who can serve as guardian for your children. And if you've got that nomination in place, those folks can step in without any question and become the guardians for your minor children. And if you don't have that in place, what we end up seeing is family members who are either fighting to take guardianship or fighting to not take guardianship over those children. And so it's really important for the client to think through, who do I want to raise my kids? Who do I not want to raise my kids? And sometimes it's the latter that drives that decision. But ultimately, if you don't decide, you're putting a judge in the position of deciding who's best to raise your kids. And those, that judge is not going to know your family well enough to make that decision.
Yeah. And I think it goes back to what you mentioned earlier when I asked, what is an estate plan? And maybe the shortest answer is it's just you being in control of the situation as opposed to leaving it up to whoever's left. And like I said, I didn't realize when we first had kids, we didn't have our documents in place for a while. And I didn't realize, hey, if something happens to me and my wife, my kids don't just automatically go to my parents or to my sister. They sort of go to, I don't know if go to the state, so to speak. And now my family's got to figure out who's going to do this, and maybe they don't agree. And to your point, maybe it ends up being somebody we didn't really want. Whereas had we had this stuff done on the front end, we get to be in ultimate control of what happens to the kids, to our stuff. Maybe we want it to go to charity or whoever. The judge isn't going to know our intents, our wishes, that kind of stuff.
Yeah, exactly right.
Okay, so we touched a little bit on the guardianship for the kids. I want to just, like I said, I think oftentimes that may be addressed through the will, but what's the purpose of a will?
So the will is a way of transferring assets that are in your name upon your passing to family members or whoever you want to receive them. And at least that's traditionally the way the will is used. So a last will and testament says, upon my passing, these are the people that I want to receive my stuff. And you can be very descriptive in your will and lay out particular items that go to particular people, or you can, sort of generally say, look, divide my stuff 50-50 between my kids. So it can be written in a lot of different ways, but it really just says, if there's something in my name upon my passing, here's what I want to do with it. Now, in modern estate planning, we don't typically use the will in that way. The way we use it nowadays is as a backstop, as a net under the trapeze for your trust. And so the reason we do that is there's some limitations that the will has. First of all, a will is a ticket to probate, right? If what you have in place for your estate plan is a simple will, the only place where that will is valid is in probate court. So you've really just guaranteed yourself that you're going through the probate process, which, as we've already said, is time consuming and expensive. So we don't like to rely on the will as our primary estate planning vehicle, but instead, if we can use it as a catch-all, so that if we forget to put something into our trust, the will take care of it and ultimately pour it into our trust. So what we'll do is we'll name our trust as the primary beneficiary, the only beneficiary on that will. So my last will and testament will say, upon my passing, if you find something in my name, put it into my trust. And that makes sure that at the end of the day, everything is going to end up where we want it to go. And the thing about the will, in addition to being a ticket to probate, it also takes away all of our ability to control those assets. So let's say in your case, Austyn, if you were to blast off now with young kids at home, and all you had in place was the will is going to dump, let's say you and your spouse passed away together, okay? And those assets are now dumping onto your kids. There's no way within the will to control how those assets are used by your kids, who's going to manage them until they get old enough, all of those kinds of things, unless you either build a trust into your will or you build a trust during your life through like a revocable living trust.
So let's talk about the trust then, because I think that is another maybe misconception that people have, is that trusts are for wealthy people. You hear about trust fund babies or whatever, right? Sort of is out there. But
yeah,
it sounds like what you're saying is really everybody can have a trust. A trust makes sense for everybody, and it gives you a little bit more control and ability to designate who's in charge of doing what with your estate. So are trusts only for the wealthy?
No, I think trusts are really for just about everybody. Again, there's lots of limitations to the will. What the trust does is it's going to give us a few really key benefits. The first one is control. Both during your life and after your passing, we want to have a good system of control in place that will allow you to determine where the assets go and then what happens to them after you're gone. So, for example, with a trust, we can say, when I'm gone, I want all of my assets to be held in trust for the benefit of my children, and I want the trustee of the trust to make distributions to my kids for education. And then when they reach a certain age, I want you to open it up for them to be able to buy a house. And you can be very, very specific in your trust about how those assets are to be used. And ultimately, you could say the trust almost owns those assets. It controls their disposition, and any instructions that you put on them, even if you're gone, still have to be followed. And so your trustee takes on that fiduciary responsibility of making sure the trust is followed, in accordance with the terms that you set up for it. So that control piece is going to be really key. When the kids get access to those funds, a lot of our clients are concerned about getting too much to their kids too early. If
Right.
you're 18 and you inherit $1 million, what's the first thing that you buy?
I'm probably going to Vegas.
Right. Well, so what we want to do is we want to make sure that the kid isn't going to Vegas, but that they're, getting an education or starting a business or,
Right.
doing something responsible with those funds. And the trust gives you the ability to control that. The trust also gives us the ability to asset protect. So everything that you leave to your kids directly through your will is going to be owned by them and can be taken from them by, through frivolous lawsuits, divorcing spouses, any of that kind of stuff. If you leave those assets for your kids in trust, nobody can touch the assets that are in there except for the beneficiary. So the trustee can make distributions to your kids, but if somebody's suing your kids, those are not assets that show up. Those are not assets that the creditors can come after. So a tremendous amount of protection is provided through trust planning.
And I think that's really important too, because what I'm finding is that people have more assets or stuff than they think. And a lot of the time that's because they're getting life insurance or something through their work, right? So
Yep.
just on your day to day, you're like, well, yeah, I don't have a ton of money. Like, it's not going to be that big of an issue, but it could be several $100,000 upon your death that just shows up out of nowhere that nobody knows what to do with because you had this insurance policy through work or something like that, right? And so having a plan for all of that before it happens just makes everybody's life easier.
Yeah, the other benefit of the trust is going to be that we're going to avoid probate. If we can get all of the assets into the trust and not have anything in your name. Remember, we said probate was the process of transferring assets from your name to the names of your beneficiaries. Well, if you've already transferred the assets out of your name while you're living and put them into your trust, we don't have to go through probate. So we're going to avoid probate. We're going to asset protect the assets. We're going to be able to control them for a much longer period of time and under much better circumstances, all while using the trust. And as you said, a lot of times, you might be maybe a newly married couple and have only a life insurance policy and a couple of minor children. Well, that life insurance policy is an estate, right? It's creating some wealth that you need to direct. And if you don't direct it, then it's going to end up dumping on these kids at a time when they're not likely to make the best decisions with it. So if you don't do an estate plan, in other words, the state of Utah is going to create an estate plan for you that says, give all the kids the money at 18, which is probably the worst possible estate plan you could think of. And so we really want to be intentional about thinking through with the client, what would be best for your kids, and then drafting a trust that really incorporates the kinds of things that the client wants to incentivize for their kids, for example. So one of the things we're doing a lot of lately is creating trusts that have kind of a banded time period where we say, look, between the ages of 18 and 30, we don't want to do anything that would screw up these kids. And so the trust after our passing, if our kids are under those or between those ages, we're only going to provide money for education, down payment assistance, a wedding, and maybe healthcare. Just a key couple of things that we want to incentivize. And if we do that, we're ensuring that the kids aren't going to get too much too quickly. We're ensuring that they're going to have funds for their care, but not too much. And so it's a great way of sort of planning and preventing your kids from making an irresponsible decision with those funds at an early age.
Yeah. And we tend to prefer that, at least early on for sure, that sort of staged distribution approach. Because one of the things, you hope that you live a long life and that over the course of your life, you have the ability to instill sort of your vision and your values and, all of those things on your kids, grandkids, et cetera. But if something happens before you have a chance to do that, in the trust, you can try to duplicate that to a certain extent, right? You can say, look, like you said, education is really important to me or whatever. So for this time period, we're going to focus, hey, education, you got it. Whatever you want to do education wise, but the Ferrari, maybe he's going to have to wait till the next time, man, right? Or whatever. So having that ability to build in some of those values and which, again, I know you and I have talked about this a lot offline, but maybe more important than the money is what type of values and what is the purpose of that money, right? And so having that staged approach can help try to force that in if you don't have a chance to do it while you're alive.
Yeah, I mean, we often think of money as, like more money is always better. And, what could be bad about inheriting money? But there's actually quite a lot of things that could go wrong in receiving an inheritance. And so we want to make sure that doesn't happen, right? We want these trusts to sort of take the Hippocratic Oath of first do no harm and, make sure that we've thought through how the money can be used and how the money should not be used. And as you said, we can really build in a client's values into the trust. So if the client really values education or entrepreneurship, those are things that we can resource within the trust and say, hey guys, you guys have money to access education. And but then even then we can be very specific about what kind of education will the trust pay for? What kind of standards do I have to maintain to receive money from the trust? Do I need a certain GPA for the trust to continue to pay for this? So there's lots of specificity that we can get into with a client in terms of structuring the trust that they're not going to see from a form trust or a form will that they might find online.
Yeah, we're seeing that more and more. And, I'm sure there are certain instances where some of those online solutions can make sense. But if you really want to try to get your heart and soul into this, having a guide. So, I'm going to turn you into a guide here, but a guide through the documents and just your experience of all the situations and all the clients you've talked to, thinking through a lot of these things, as opposed to somebody just at home trying to figure it out themselves and hope it goes well.
Yeah, what I found is, I get asked the question a lot, what do you think of different software companies out there that will draft a will or a trust for you? And I've reviewed a lot of them. And most of the time when I review them, the problem is not with the document itself. I've seen pretty good documents come out of some of those software programs. What tends to be the problem is that the client doesn't usually understand well enough the process and what they should be thinking about, how they should be thinking about it. And so the inputs that they give the machine don't produce the outputs that the client is looking for. And so, I'll often ask the client, what is it that you think your will or trust does? And then they'll tell me, and it doesn't match with what they've produced in the program. And so, that's part of it, is that it's helpful to have somebody walk you through the options and what makes sense for your family, based on our experience and what we've seen and some of those kinds of things.
Perfect. Well, I think that's enough time on the will and trust. I know those are the two, or at least from my perspective, the two sort of foundational pieces, but there's a couple other documents we always want our clients to have as part of this basic package. One of those being the living will. And, that's a word I think people hear, but they may not. I think oftentimes people get the will and the living will confused. So let's talk about the living will for a second. How does that differ from just the will, and what's the purpose of having that in place?
Yeah, living wills, it's kind of a terrible name for it because it only creates confusion. But the living will is better known as the pull the plug document. And it's the one that says, if I am ever in a terminal condition or a persistent vegetative state, what do we do about it? And it gives you the opportunity to indicate your preference. So for most folks, it's saying, look, if I'm ever in this position, I want the plug pulled. I do not want to be kept alive artificially. So if a respirator is keeping me alive, go ahead and pull the plug on that respirator. A living will is not a do not resuscitate, right? That's a different thing. It's something we see much older clients getting where, do not resuscitate says, look, if I'm coding, I'm having a heart attack, don't resuscitate me. Don't give me life-saving CPR. That's different, right? We're not signing our life away in that way when we execute a living will. All we're saying is, if I'm being kept alive by a machine and I can't communicate my wishes, this is what I want you to do. And there was a big case, many years ago now, a woman named Terry Schiavo. She was in a persistent vegetative state, and her husband came forward and said, hey, Terry didn't want to live this way. We need to pull the plug. Her mom and dad came forward and said, absolutely not. You can't pull the plug on our daughter. And it turned into a over 10-year long fight in the court system. They kept Terry alive for over 10 years fighting about this. And it really woke people up to the idea that it's not enough for you to tell your spouse, yeah, I want you to pull the plug. You really need to have those documents in place in case it becomes a family fight. But even more important than solving potential disputes between family members, I think the benefit of the living will is taking the burden off of your family members so that they don't have to make that difficult decision. You've already done it for them.
Yeah, that is such luckily I haven't had to be in that position yet, but you can just think of the mental and emotional sort of pain and anguish over that you would feel in having to make that decision for your spouse or for your parent or whoever it is without knowing what they wanted to do. So I do think that's a critical piece there. That last point you mentioned is just it takes that guilt or pain away because this is what that person wanted.
Exactly.
Okay, so we got the will, we got the trust, hit on the living will. The last piece, and you mentioned it a little bit earlier, but is the financial or the power of attorney piece, right? I think of it as sort of financial power of attorney. When we're dealing with clients in a situation like this, we need that on file so whoever they've chosen can make decisions for them if they're unable. But talk about real briefly just purpose of a power of attorney and when that may come into play.
Yeah, so the power of attorney comes in two forms, and we want clients to have both. There's a financial power of attorney and a healthcare power of attorney. So with the power of attorney, what you're doing is you're appointing an agent who can act in your stead should you become incapacitated. So if you can no longer speak for yourself, we want somebody who can do that for you. And there's only two ways for somebody to speak on your behalf. One is if the court appoints them, and two is if you appoint them. We don't want to have to go through court in order to get a guardianship or a conservatorship for you. If we have a financial power of attorney and a healthcare power of attorney, we can avoid that. So let's say, Austyn, that you are crossing the street, you get hit by that school bus, and now you're laid up in the hospital and can't speak for yourself. If you don't have a power of attorney, your wife is not going to be able to step in and manage your affairs. She's not going to be able to make treatment decisions. She's not going to be able to sign your tax return. She's not going to be able to handle any of that stuff. So she's going to have to go and get a guardianship and a conservatorship. It's, again, time consuming. It's expensive. If we have those simple powers of attorney in place, we can avoid all of that hassle.
With all these different documents that we've talked about today, how often do you recommend taking a look at who you've chosen, just updating your plan, I guess, maybe is the easiest way to say it. So, I come to you and I get all this stuff put in place. How often do I need to be coming back to you to review and adjust?
It's a good question. So once your estate plan is in place, because your family's never complete, your estate plan's never probably officially complete. You could think of it more like landscaping, where there's maintenance.
Oh, don't make me think of landscaping. That's my nightmare.
There are some things that you'll want to update on occasion, but typically what we tell clients is, once your estate planning is done, every couple of years, we want you to pull it off the shelf and say, okay, have there been any major changes in my life? Birth, death, divorce, significant accumulations of wealth, drastic changes in your net worth, all of those kinds of things would necessitate, taking another look to make sure that it still does what we want it to do. And so even though your documents aren't going to technically expire, we do think it's a good idea to every 2 years, say, pull it off the shelf and say, okay, does this still match with what we wanted, and are there any updates to be made? And the most common update that we'll make to documents is updating trustees. So the trustee is the person that administers your trust, and that's normally going to be you during your life, but then you might have some specific people that you've chosen to be the trustee for your kids, for example, when you're gone. Well, sometimes those relationships fade and you need to put somebody else in that you trust more. And so we'll update trustees. And then updating your assets. That's the biggest thing, is that you're going to continue to acquire assets over your lifetime. And so we need to make sure that as you acquire those assets, they end up inside your trust, so that we don't have to utilize that will to get them into your trust, that backstop that we talked about.
I'm glad you mentioned that, because that, I think, is the thing. Having a trust is not enough. You got to actually put stuff in it. So as part of a financial plan for our clients, that's one of the things we help them with, right? Is where are all your accounts? How are they titled, and do they need to be in the trust? But that's a living and breathing process, because you're always sort of acquiring new things or getting rid of other things. And, the estate planning process is a living and breathing process, just like financial planning. It's something that needs to be reviewed.
Yeah, exactly. Your assets are going to change, and we want to make sure that as those change, you've updated. So for example, you can kind of go asset class by asset class and say, if it's real estate, for example, we need a deed to get that into the trust. If it's, a life insurance policy, we'll typically name the trust as the primary beneficiary of that life insurance, so that the funds pour into the trust. You're not actually transferring the life insurance in some cases. And so depending on what the asset is, we have a different instruction for how we're going to get it into the trust. But ultimately, we want to make sure that all of those assets are in the trust. That's probably the biggest mistake that people make in putting a trust in place, is they don't properly title their assets so that they all end up in the trust upon your passing.
One of the other benefits to having a living, breathing attorney as well as financial advisor. So, Eric, we really appreciate you coming on with us today to talk estate planning. If you have any questions for Eric or myself, please feel free to reach out to me. You can shoot me a text, 801-839-7056, or you can check out our website at wittenbergwealth.com. And please remember to subscribe to the Wealth of Insight podcast and share with your friends and family.
Thank you for listening to the Wealth of Insight podcast. Click the subscribe button below to be notified when new episodes become available. Securities offered through LPL Financial, member FINRA SIPC. Investment advice offered through Stratos Wealth Partners, a registered investment advisor. Stratos Wealth Partners and Whittenburg Wealth Partners are separate entities from LPL Financial. The information covered and posted represents the views and opinions of the guest and does not necessarily represent the views or opinions of Whittenburg Wealth Partners. The content has been made available for informational and educational purposes only. The content is not intended to be a substitute for professional investing advice. Always seek the advice of your financial advisor or other qualified financial service provider with any questions you may have regarding your investment planning.